All right, California tenant rights. Sounds like a pretty hot topic, especially for an attorney like you dealing with evictions day in and day out. I know you're based in Santa Ana at the Martinez Law Center, and you're focusing on helping tenants in Orange County and the surrounding areas. We've got a ton of info here, articles, guides, all about those California landlord tenant laws. And I know there's some big changes coming in 2025, so let's get into it.
Yeah, California definitely has a rep for being pro-tenant, right?
For sure.
But the thing is, the laws are designed to kind of walk this tightrope, trying to protect both landlords and tenants.
Here's that balance.
But that balance definitely makes things pretty tricky, especially from a legal standpoint.
So I guess the big question is, with all this information, where do we even start? What are the absolute must-knows for someone like you who's on the front lines of tenant defense?
Well, I think we got to start with the foundation, right? The landlord's duty to provide a habitable living environment. This is something that comes up again and again in all of our sources. Both the Azebo and Dorluke articles really hammer this home.
Makes sense. That's got to be the starting point, right?
Yeah, and it might seem kind of basic at first glance, but it goes way deeper than just providing a roof over someone's head.
Right. I was going to say habitable. That's a pretty loaded term in California law, isn't it?
Yeah.
It's not just about, whether the paint is peeling or the carpet's a bit old.
Exactly. We're talking essentials here. Working plumbing, heating, electrical systems, things that directly impact health and safety.
Of course stuff.
And California, they're pretty strict about this. They set very clear timelines for landlords to get these repairs done. For most issues, it's 30 days.
30 days.
But if it's an emergency, well, that's a whole different ballgame. They need to act immediately. And trust me, emergency is not a loosey-goosey term here.
Yeah, so we're not talking about a leaky faucet. We're talking about a broken heater in the middle of winter or something like that.
Exactly.
Got it. So it sounds like for an attorney like you, solid documentation of those issues, how bad they are, when the landlord was notified, what they did or didn't do about it. That's got to be crucial, right?
Yeah.
Especially when you're trying to help someone facing eviction.
Oh, absolutely. I mean, detailed records, that's a tenant's best friend. Photos, videos, emails, letters, anything that proves the problem existed, that the landlord knew about it, and that they just didn't fix it in a reasonable amount of time. That kind of evidence can make or break a case in court.
And speaking of things landlords can't do, didn't both Azebo and Dorluke mention that 24-hour notice rule for landlords wanting to enter a rental unit?
Oh, yeah, that's a big one. And this isn't just a friendly suggestion. This is the law.
Yeah.
Unless it's a real emergency, like a fire or a burst pipe, a landlord can't just waltz in whenever they feel like it.
Right.
They have to give written notice at least 24 hours in advance, stating the date, time, and reason for entry.
So no more surprise inspections or just dropping by to chat.
Exactly. No vague excuses about maintenance either.
California is pretty clear about this. A tenant's home is their castle. Their privacy is sacred.
Absolutely.
Okay, so let's talk about something else that can cause a lot of headaches in these landlord-tenant situations, security deposits.
Mm-hmm.
The FAQs we have mentioned, a cap on how much landlords can charge for these deposits, right?
Yeah, for most situations in California, the security deposit can't be more than 1 month's rent, regardless of whether the place is furnished or not. But there's this little quirk in the law you got to watch out for, something called the small landlord exception.
Oh, yeah, I remember hearing about that. What's the deal with that exception?
So if a landlord owns a smaller property, like a duplex or a single-family home, they're actually allowed to charge up to 2 months' rent for the security deposit.
It's 2 months, okay. So knowing who actually owns the property, like the exact ownership structure, that's super important.
Oh, it's crucial, yeah. I mean, it could make a big difference in how you approach a case. So those initial client interviews, you really got to dig deep, get all those details to figure out which rules apply in each specific situation.
Makes sense. So even with those caps on the amount, getting that deposit back can be a whole other battle, right?
Mm-hmm.
What are the key things tenants should know about that process?
Well, first and foremost, California law gives landlords 21 days after the lease ends to return the security deposit.
Okay, 21 days.
And if they're deducting anything for damages, they have to provide an itemized statement, explaining exactly what those deductions are for.
Right, an itemized statement.
But here's where things get really interesting. Starting in 2025, get this, landlords are going to have to provide photographic evidence of any damages they claim.
Photographic evidence, that's a game changer.
Yeah.
I mean, think about how much that's going to change things when it comes to documenting the condition of a property.
I know, right? It's going to force both landlords and tenants to be way more meticulous about documentation. Landlords are going to need those crystal clear before and after photos to justify any deductions, and tenants, Well, they're going to have to be just as diligent in documenting the condition of the place when they move in. It'll be interesting to see how this plays out in real life, how it affects legal strategies going forward.
It's almost like a whole new area of law is emerging around this photographic evidence rule.
Yeah, it's definitely something we're going to need to keep a close eye on.
For sure, for sure. Okay, let's shift gears a bit and talk about another hot-button issue, rent control. California is known for having some pretty strict rules in this area, and I know it's a big concern for tenants, especially with housing costs going up, up, up. What are the essentials everyone needs to know?
Well, the foundation of rent control in California is this law called the Tenant Protection Act, also known as AB 1482.
AB 1382, got it.
This law sets a limit on how much landlords can raise the rent each year.
And I think that cap is tied to inflation, isn't it? It's not just some fixed percentage.
That's right. Across the state, landlords can't increase the rent by more than 5% plus whatever the change in the consumer price index is, or 10% total, whichever is less. So the exact amount can fluctuate a bit from year to year, depending on how much things are costing.
Okay, makes sense. So that's a pretty tight control on rent increases. But I've heard that a lot of the cities actually have even stricter local ordinances that go above and beyond that statewide cap. Is that right?
You're absolutely right. Places like Los Angeles, San Francisco, Oakland, they all have their own rent control laws that are even stricter than AB 1482.
Wow. So it's not enough to just know the statewide rules. You got to be up on the specific ordinances for every city you're working in.
Yeah, it's a lot to keep track of.
Sounds like a real legal minefield, especially for someone like you who's handling cases across multiple counties.
It definitely keeps things interesting.
Okay, let's move on to another area where California law really steps in to protect tenants, and that's evictions. Given your focus on eviction defense, this is probably where things get really real for you, right?
Oh, absolutely. Eviction, it's always a tough situation, emotionally charged, and the laws in California are very specific about the procedures landlords have to follow.
Right.
And with the recent changes that have been made, those procedures are actually becoming even more tenant-friendly.
Interesting. I remember reading about something called just cause evictions in one of the articles. Can you explain what that means exactly? It sounds like landlords can't just kick someone out on a whim anymore.
That's the gist of it, yeah. These just cause laws, they're becoming more and more common across the country, and they basically require landlords to have a legitimate, legally recognized reason to evict someone. It's not enough to just decide you don't like a tenant or want to rent to someone else.
So no more, I just don't like you evictions.
Very much, yeah.
Okay, that's a big win for tenants.
It is. And even when landlords do have a valid reason, like unpaid rent or a lease violation, they still have to follow a very strict process.
Didn't the door loop guide go into detail about all the different types of notices landlords have to give? I seem to remember there's a specific notice for every situation, and using the wrong one can totally invalidate the whole process.
That's exactly right. For example, if a tenant is behind on rent, the landlord has to serve them with a 3-day notice to pay rent or quit. If it's a lease violation, well, there's a whole different notice for that. And if a landlord tries to cut corners or uses the wrong notice, it can actually create a legal opening that you can use to defend your clients.
Oh, I could definitely see how those procedural missteps could be a huge advantage in court.
Oh, for sure.
It's all about knowing the rules inside and out and holding landlords accountable for following them to the letter. But even if a landlord does everything by the book, California still gives tenants some pretty significant protections when it comes to facing eviction, right?
Absolutely. And one of the most important ones is that requirement for a solid legal reason for the eviction. This is where that just cause idea comes in again.
So even if a tenant is late with their rent or has broken a rule in the lease, there might be other things that could help them avoid getting evicted.
Exactly. California law recognizes that life happens, sometimes things get in the way.
Yeah.
And there are often mitigating circumstances that can lead to those lease violations. So, for instance, if someone suddenly gets sick or loses their job and they can't pay their rent on time, a judge might be willing to work with them to come up with a payment plan so they can stay in their home.
Okay, so it sounds like in this area of the law, it's not just about understanding the black and white of the lease. It's really about the human element, being able to present a compelling case on behalf of your clients.
Right. That's exactly it. And it's not just about preventing that initial eviction either. California law actually gives tenants some rights even after a judge has ruled in favor of the landlord.
Wait, really? What kind of rights are we talking about? I always thought once a judge issues that eviction order, That's pretty much the end of the road.
Well, not always. For example, California gives tenants a 5-day grace period to move out, even after they've been served with a writ of execution.
A 5-day grace period. That's more generous than I would have thought.
Yeah, it gives people a little breathing room to find another place to live and figure out what to do with their stuff.
Right.
And I think it's a good example of how California law, even though it aims for this balance, it does offer some pretty strong protections for tenants, even when they're facing eviction. It's not just about landlords' rights. It's about making sure the process is fair for everyone.
Definitely. Okay, so we've got all these important protections in place, but I know there are some big changes coming in 2025 that are going to shake things up even more. I'm particularly interested in the updates to those application fees. I've heard rumors that landlords are going to have to be a lot more careful about how they handle those.
Oh, you heard right. Those 2025 updates are going to have a big impact on how rental applications work. Those days of landlords collecting a bunch of applications and fees, then just picking whoever they want, pretty much over.
Wait, seriously, so how are landlords supposed to screen applicants now? I mean, they've got to have some way to figure out who's going to be a good fit for their property, right?
The new law gives them a couple of options.
Okay.
They can lay out all their screening criteria up front in detail, and then they have to choose the first qualified applicant who applies. No more waiting around for a better candidate or rejecting someone based on some vague feeling.
So if someone meets all the criteria they're in, no matter who else applies later on, that's a pretty big shift in power.
It is, definitely. And if landlords decide they don't want to go that route, well, there's another option. But it comes with a bit of a catch. They can still collect multiple applications and choose whoever they think is the best fit, but
There's always a but, isn't there? I have a feeling there's going to be some kind of trade-off if landlords want to keep that control over who they choose.
you got it. In that case, they have to refund the application fees to everyone they don't choose. Doesn't matter if those folks met the screening criteria or not.
Wow, that's a pretty strong incentive for landlords to just be upfront about their criteria and stick to that first qualified applicant rule, right?
You bet. It seems like these new laws are trying to make things fairer for tenants, stop landlords from taking advantage during the application process.
Makes sense. And these changes to application fees, that's just one piece of the puzzle, right? The 2025 updates also include some important changes to credit reporting for tenants, and there are new restrictions on charging fees for certain notices. It's a lot to process. I think we need to unpack those changes, really explore what they mean.
I agree. Those 2025 updates, they deserve their own deep dive. Let's dig into those details when we come back.
Okay, so we've talked about a lot. Habitability, privacy, security deposits, rent control. But before we move on, I'm really curious about those changes coming up in 2025.
Yeah.
Especially the stuff about credit reporting for tenants. The Wire Associates video made it sound like a pretty big deal.
It is, yeah. It's a big shift. You know, for a long time, tenants haven't really gotten credit, literally, for paying their rent on time. Like, you pay your other bills, it shows up on your credit report, but rent, not so much.
Right.
But starting in 2025, California law is going to require landlords to report those on-time rent payments to the credit bureaus.
Okay, so that's good news for tenants, right? It'll
Right.
help them build their credit.
It could be, yeah, but there's a catch.
There's always a catch.
It's only if the tenant asks for it, it's not automatic.
Oh, interesting. So it becomes kind of a strategic decision for tenants then.
Exactly. On the one hand, having those rent payments on their credit report, that can be huge, especially for tenants who are trying to improve their credit score. Maybe they're thinking about buying a house or getting a car loan, you know?
Right.
But on the other hand, landlords are allowed to charge a little fee for this service. I think it's like $10 a month, something like that.
So tenants have to weigh the pros and cons, figure out if that credit boost is worth the extra cost. That's a conversation I can see having with a lot of clients, helping them figure out what's best for their situation.
Yeah, definitely. It's all about personalized advice. For some folks, that credit boost might be worth every penny. But for others, maybe it's not a priority.
It's another example of how these new laws, they're making things more complicated, but they're also opening up opportunities for attorneys to give really strategic advice, right? It's not just about knowing the rules, it's about helping clients navigate those choices.
Absolutely. And it's not just credit reporting that's changing. Landlords are going to have to be more careful about charging fees for all sorts of notices starting in 2025.
Oh, yeah. The Wire Associates video touched on that.
Yeah.
I remember thinking, it's about time.
Right.
It always seemed kind of unfair to charge tenants just for receiving information, especially if it's something like an eviction notice. It just felt like rubbing salt in the wound.
I know, right? It felt like adding insult to injury.
Yeah.
But the good news is, starting in 2025, landlords won't be able to charge fees for any of those legally required notices.
Oh, okay.
Whether it's a notice to end the tenancy, a 3-day notice to pay rent or quit, any kind of notice, no more fees.
So that's one less thing for tenants to worry about. It might seem like a small thing, but it all adds up, right?
It does. It all helps. Every little bit counts. And speaking of helping, there's one more 2025 update we should talk about, and this one's really relevant to what you do. That change to the timeline for responding to an unlawful detainer lawsuit.
Oh, yeah. That one definitely caught my eye. That shorter time frame always felt like a real disadvantage for tenants who are trying to put together a defense.
Yeah.
Especially with those more complex cases.
Exactly. Yeah. Before 2025, tenants only had 5 days to file a response to an unlawful detainer lawsuit.
5 days, that's not a lot of time.
5 court days, which is even worse.
Right.
It's tough to gather evidence, talk to an attorney, and put together a strong defense in that amount of time. But starting in 2025, they're doubling that timeline. Tenants are going to have 10 whole court days to respond.
10 days. That's huge. That gives us attorneys so much more time to build a solid case, explore all the options for our clients.
It really is a game changer. And if the notice is mailed, tenants get an extra 5 days on top of that, so they could have up to 15 days.
Wow, 15 days. Okay. That's a big difference. It really levels the playing field, gives tenants a fighting chance to protect themselves.
Exactly. And I think it highlights how important due process is. Even in these eviction cases, that can move pretty fast.
It does. And it reminds us that justice takes time, right?
Yep.
Rushing the process doesn't help anyone. This change, it's a good step. Make sure tenants have the time they need to prepare a defense. So we've got these big changes coming. Application fees, credit reporting, notice fees, the unlawful detainer timeline. It's like California's rewriting the rules of the landlord-tenant game.
It's a big shift, that's for sure. Landlords and tenants are both going to have to adapt. But overall, I think it's a good thing. More transparency, more fairness, more accountability. That's what we want to see.
Yeah, definitely. It seems like California lawmakers are making it clear tenant rights matter. But even with all these new protections, it can still feel pretty overwhelming. All the little details, the local ordinances, the laws are always changing.
It's true. It's a complex area of law. Staying up to date is so important. That's why I'm glad we're having this conversation to help you navigate all this, give you the knowledge you need to really advocate for your clients.
Knowledge is power, right?
Exactly.
Well, I've got to say, I'm feeling a lot more confident about all this now, thanks to you.
You're doing great. And remember, you're not alone in this. There are tons of resources out there. The California Department of Consumer Affairs, local housing authorities, tenant advocacy groups, they're all great allies.
Good point. I'll definitely be checking those out. But for now, I think we need a little break. Let's take a breather. Come back refreshed for the final part of our deep dive into California tenant rights.
Sounds good to me. Let's take a pause and we'll wrap things up when we get back.
All right, we've been through a lot in this deep dive. We've talked about everything from habitability and privacy to, the ins and outs of rent control and those tricky eviction procedures, plus all those crazy changes coming up in 2025. It's a lot. Yep. But as we wrap things up, I'm kind of curious. My practice focuses specifically on evictions.
Yeah.
I'm an attorney at the Martinez Law Center in Santa Ana, and we're all about fighting for tenant rights here. We handle cases in Orange County, Riverside, San Diego, even Los Angeles. So for attorneys like me, who are right there on the front lines of these eviction battles, do you have any final words of wisdom?
Oh, that's a great question.
What are the big takeaways?
I think the most important thing is to stay informed,
Yeah.
Be proactive. California tenant law, it's a moving target. New laws, court decisions, strategies, it's always changing.
It's a lot to keep up with.
It is. Subscribe to legal journals, go to conferences, connect with other attorneys who are doing this work. That's how you stay ahead of the game.
Makes sense. You can't just know the basics anymore. You got to be ready for those little changes, those new trends that pop up.
Exactly. And don't be afraid to think outside the box, Challenge the way things have always been done. The law, it's not static. It's constantly being reinterpreted, especially in light of new situations.
So get creative with it.
Yes. The best tenant rights attorneys are the ones who not only know the law backward and forward, but they're passionate about justice. They're ready to fight hard for their clients.
I love that. So it's not just about Winning cases, it's about making sure things are fair, making sure tenants have a voice in a system that can often feel like it's working against them.
That's it. And remember, every single case is a chance to make a difference, not just for that one client, but for the whole tenant community.
So each victory, even a small one, it contributes to the bigger fight for tenant rights.
It does. And it can inspire other tenants to stand up for themselves, challenge landlords who are doing the wrong thing.
That's powerful stuff. It's not just legal battles. It's about giving tenants power, building a more just and equitable system for everybody.
Exactly. And don't forget, you're not alone in this. There's a whole network of people fighting for tenant rights, legal aid groups, community organizations. We're all in this together.
It's really inspiring to know that there's this whole community dedicated to this cause. I'm definitely feeling fired up, ready to tackle those tough cases.
That's what I like to hear.
And knowing that I'm part of this bigger movement, that makes a huge difference.
It does. And if you ever need help, advice, anything, don't hesitate to reach out to those organizations, those other attorneys. We're here to support each other.
I appreciate that. I'm feeling a lot more prepared to handle whatever comes my way thanks to this deep dive. But before we go, I wanted to let everyone know if you're listening and you need legal help with tenant rights issues, come visit our website, martinezlawcenter.com. We're here to fight for tenants. We're here to help.
That's a fantastic resource. It's so important for tenants to know they have options, that there are attorneys out there who are on their side.
Absolutely. So to all the tenants out there, know your rights, stand up for yourselves, and don't be afraid to ask for help. Get a lawyer on your side.
Couldn't agree more. And to all my fellow attorneys who are out there fighting for tenant rights, keep up the amazing work. The fight for housing justice. It goes on.
This has been fantastic, really eye-opening. I feel like I've learned so much. And thanks to you, I'm going into these battles feeling a lot more prepared. To everyone listening, thanks for joining us on this deep dive into California tenant rights. It's been inspiring, empowering, and I'm walking away with a ton of new knowledge to share with my clients and colleagues. Until next time, stay informed, stay involved, and keep fighting for a fair housing system for all.
Call now 714-442-9741. Thank you.